Will Elizabeth Holmes get the 15-year prison sentence that the government wants? Or will she be sentenced to 18 months of home detention, no prison? That's what the defense wants. Or will she get 9 years in prison, which is what the probation department is recommending to the judge? Well, in this video, I'm going to walk you through I'm going to highlight some of the areas in the sentence recommendation filed by the prosecution, as well as I'm going to point out some of the areas in dispute where the defense is objecting, and I'm also going to give you my analysis of what I think the likely outcome is going to be. We're also going to take a look at the sentencing table, the calculation, and some prior cases. What kind of sentences did those defendants get? So hi there, I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case and the Sunny Balwani case and several other cases, and I've done a ton of videos. So if you want to know what the defense argued, go ahead and take a look at the video I did called Holmes's Plea for Substantial Leniency. That's that 18-month home detention recommendation that the defense is making to the judge. In other words, let Elizabeth Holmes stay at home, continue her community service. She doesn't need to go to prison. That's what the defense is basically arguing, okay? But now let's look and see what the government is arguing. So, again, this video is for education information. It's simply my analysis, my opinion. So please do leave a comment or question. I want to know what your analysis is. And please hit that like button. Do subscribe. Thank you to all of those of you who have subscribed. Please support my work by subscribing. And if you want to contribute to me making these videos, I put a PayPal link in the description box below the video. But before I get to that sentencing recommendation, just in case you popped onto this channel, I'll give you a little bit of background. So Elizabeth Holmes started a blood testing company called Theranos. She was the CEO. Sunny Balwani was the COO. They were tried separately for wire fraud. Elizabeth Holmes was convicted on 4 counts. 1 of conspiring with Sunny Balwani to defraud investors, and then 3 counts for defrauding individual investors to the tune of approximately $144 million. But the government is arguing that it's way over that. It's in excess of $550 million. Now, how did they get there? So stay tuned. I'll get to that. Elizabeth Holmes will be sentenced on November 18th. And she, each one of these counts carries a maximum sentence of 20 years. So 4 plus 20 is 80 years, potentially, if the judge applies it consecutively. So you can look at the videos I did on calculating Elizabeth Holmes' sentence, whether or not the judge would even do a consecutive sentence. And also, we're going to look at how each one of these parties calculated this sentence, right? So let's go ahead and take a look at the sentence memo. Or actually, let me look at the calculation first. Let me show you that first. So the probation, when a defendant gets convicted, the probation department does a pre-sentence report, which they give to the judge and to both of the parties, both to the prosecution and the defense. So the probation officer gathers all the facts, does an interview with Elizabeth Holmes, talks to all the victim investors, interviews any other potential victims, gathers all the amount of loss. You know, was it 144 million? Was it 550 billion? What was the amount of loss? Because that determines the higher the loss, the more you go down in the sentencing table and the more prison you are facing, okay? So here is the sentencing guideline calculation because it was redacted in the defense's sentencing recommendation, but it was in the prosecution's sentencing recommendation. So now we know what the probation department is recommending as far as the calculation. So it says here, the PSR stands for the pre-sentence report, calculates the total offense level as follows. A, the base offense level, so it's level 7 because it's a fraud count. Then they add, depending on the amount of loss, and the prosecution is alleging it's 550 million or more. Therefore, it should be a step increase of 30. And they're also arguing that there are 10 or more victims. Therefore, you need to add an additional 2 steps because of the risk of death, another 4 steps. So it's a total offense level of 43. Level 43, which is the maximum any defendant could get on the sentencing calculation. Okay? And if you notice here, they're all plus signs. So those are all factors in aggravation. There's no negative sign here, which would be a factor in mitigation. All right? So, as it says right here, the guidelines recommend a sentence beyond the statutory maximum of 80 years because she's well above, with the 550 million, well above the sentencing guidelines. But the probation, the pre-sentence report and the probation department and the prosecution and the defense also, all of them recommend to the judge to not apply this sentencing calculation of 43, level 43. No, all parties want the judge to vary from the guidelines. In other words, it could be argued to give Elizabeth Holmes leniency. All right? So I will show you, let's take a quick look at the sentencing table here so we get the big picture. So here's from the U.S. Federal Sentencing Guidelines. Again, we're just looking at the fraud count here, base level 7. Now, I said in the prior video I did on her plea for leniency, where I went over the defense's arguments for why she should get home detention. Based on their step increase, this level 7 plus the level 6 is level 13, which would be the 18 months home detention, they're saying. But even that, at that level, you're not, according to the guidelines, you're not eligible. And it's also what the probation, the prosecution argues, is that she's not eligible for home detention. So if you want to do the 18-month home detention, that would say that the amount of loss was more than 40,000, between 40 and 95,000. Well, I think the investors will disagree with you on that one. So then if you just look at the 144 million, it's at M here. M is in money. M, you add 24. So that gets her to the level 31, which is what the probation department is recommending. Level 31, okay? But if you look at P, as in penalty, it says for if the amount of loss is over 550 million, then you add 30. That's how the prosecution, or maybe I should have said P as in prosecution. They're saying you add 30 to that 7 plus the additional aggravating factors. All right, now let's see how it applies to the sentencing table. Okay, so let's start at the bottom here. So the maximum amount is level 43. So based on the pre-sentence report calculation, which the probation doesn't disagree with and the prosecution does not disagree with, they agree with that calculation. The defense doesn't, but they do. They're saying it's level 43, which could subject Elizabeth Holmes to life in prison. But that's not what the prosecution or probation is recommending. Prosecution is recommending here, look at level 35. That's 168 months to 210. They're recommending 180 months, which is 15 years. That's level 35. The probation is recommending, probation department is recommending level 31 because they're recommending to the judge 108 months, which is 9 years. Okay? So we have 15 years prosecution wants, 9 years the probation department is recommending. And then we have, look at level 13, which is the 12 to 18 months. The defense is arguing, judge, give her substantial leniency here because of all these other factors. The trauma, the rape that occurred in college, the alleged rape that occurred in college, the alleged domestic violence, the abuse, the control, the influence that Sunny Balwani had over her, allegedly. That should be mitigating. She should just get home detention, Your Honor. 18 months is sufficient to deter her. She'll never do this again. You can go ahead and look at my prior video I did on plea for lenient sentencing where I go through what the defense is arguing. Okay, so we're all on the same page here. Defense wants 18 months home detention, no prison. Prosecution is saying she's not eligible for home detention. We want 15 years. Probation is saying 9 years, Your Honor. All right, now let's take a look at what the prosecution sentencing memorandum, their recommendation to the judge, and it also indicates, because a lot of it was redacted in the sentence recommendation filed by the defense, I'm going to try to put the pieces of the puzzle together here. So again, this is just my opinion. It's for education information. Do subscribe, hit that like button, and share these videos. All right, so the areas highlighted, again, they talk about the investor fraud. They talk about the impact on the patients. They talk about the cover-up between her and Sunny Balwani, putting out those misleading articles with the press, telling Walgreens something different, the logos, misappropriating the logos, etc. And again, I'm just highlighting because this memo is 46 pages long. I'm only looking at 28 of them. So the areas highlighted here, if you look at 12, you look at line 12 through down, these are the areas that the defense is contesting. The defense is saying the loss wasn't $550 million. They're saying there wasn't any, the offense did not involve any reckless risk of death. Her conduct didn't create risk of serious harm is what the defense is arguing. They're also arguing her role in the offense was not as a leader and it wasn't extensive. Therefore, she shouldn't get these increases in her sentence. They're also arguing about deterrence. They don't think it applies. They're saying incarceration shouldn't apply. That's what the defense is arguing. The prosecution is arguing the opposite here, right? They're arguing she needs to be deterred, needs to send a strong message to Silicon Valley. They need to protect the public by the sentence. And we're also going to look at, if you look under G here, the unwanted disparities between sentencing. We're going to look at some cases, some prior sentences that the prosecution is providing in this memorandum that indicates, it's actually a wide range of sentences throughout the federal district. And it's up to this judge to determine what sentence he feels is appropriate for Elizabeth Holmes. Okay, he heard the testimony. He saw Elizabeth Holmes testify. He saw all the other witnesses and the patients testify. All right, so here it is. The prosecution is saying Elizabeth Holmes defrauded dozens of investors over the course of many years. She chose deceit over candor. Through her deceit, she attained spectacular fame, adoration, and billions of dollars of wealth. And after her fraud was revealed, she lied, obfuscated, and concealed. And she blamed Balwani, her board, the scientists, business partners, her investors, the marketing firm, her attorneys, the media, everybody but Elizabeth Holmes. She put patients at risk. She put to market an unproven and unreliable medical device. She was blinded by her ambition, her distortion of reality. She accepts no responsibility. She insists she is the victim. Prosecution says she is not the victim here, Your Honor. Holmes's crimes were not failing, they were lying. This is a fraud case. When you make misrepresentations and people invest, that's called wire fraud, right? So the prosecution is saying that the guidelines recognize that Holmes's crimes were extraordinarily serious. Among the most substantial white-collar offenses in Silicon Valley, I'm going to show you these cases. There are people who defrauded much more than Elizabeth Holmes. Okay, the prosecution is also recommending 3 years of supervised release. That means when she gets out of prison, supervised release, not parole. Parole was abolished in the 80s. It's called supervised release. That means the probation officer will keep monitoring her, generating reports, submitting them to the court if necessary, to keep an eye on her for 3 years after she's released. And they're also asking for, and this is interesting, they're asking for Elizabeth Holmes to pay restitution to Walgreens and Safeway. That's, not just the investors that she was convicted of, but Walgreens and Safeway. And how did they come up with this $550 million in loss? So let's take a look. So the trial was 4 months, 900 exhibits, 32 witnesses testified. She was convicted on those 3 counts of defrauding these individual investors, Mosley, the DeVos family, which is RDF, and the PFM fund, which was Brian Grossman. All right, so that was $6 million, $99 million, and $38 million. That's where I come up with approximately $144 million. But the prosecution is arguing, no, Your Honor, it's in excess of $550 million. That's where they come up with a step 30 increase. Okay, I went over this with you, so let's go ahead and take a look at this. So here's the argument, and this is where the defense is arguing, Your Honor, it's not $550 million. Prosecution is saying, Your Honor, you can apply what's the greater of actual loss or the intended loss. So, did she intend to inflict additional loss? They're saying, Your Honor, you could look at the big picture here. Walgreens, Safeway, other investors who lost their money. And the judge only needs to make a reasonable estimate of loss. Reasonable estimate. Doesn't have to come down to the penny. And here's where I think the defense is going to point this out to the judge. The prosecution here says the case they cite relates to a public company. Well, Theranos was a private company. So maybe the defense will argue, Your Honor, this case doesn't apply. So therefore, it's not $550 million. So then the prosecution talks about the amount of the investment that they lost, and it's a preponderance of evidence standard, meaning a lesser standard. Preponderance of evidence, okay, is the lowest standard there is, right? So think of a football field. If you get the football just past the 50-yard line, or in some jurisdictions it's more likely than not, that's considered preponderance of evidence. Clear and convincing, which is what the defense is arguing that the prosecution has to prove this amount of loss by, you have to get the football down way past the 50-yard line. It's not as high as reasonable doubt, which is what she was convicted of. I used to do these charts of, the football line. I'd line it out. I'd explain reasonable doubt versus clear, etc. So anyway, prosecution is arguing to the judge, no, it's a lower standard of proof. The defense is arguing, no, it's a higher standard of proof, which the prosecution can't meet. Therefore, the $550 million, the increased steps don't apply. She shouldn't be sentenced to that much prison. Here's, you can take a look at this, and in the highlighted part here, line 22, it says PFM. This is where Brian Grossman testified in the trial, in the Holmes trial. Invested $96 million in 3 separate wires. Well, she wasn't charged with that technically. Neither she or Balwani, for that matter, because they were both charged in the same crimes. The 966, it's over 3 separate wires. In the trial and in the indictment, there's only 1 count, and it's $38 million. So the defense, so the defense might argue, how did they come up with the $96 million over 3 wires? She wasn't convicted of that. Well, if you keep reading here, although $43,500,000 was returned back to the PFM fund out of this $96 million, they're saying, and as I pointed this out in the prior video, just because Holmes settled this case, the settlement in the civil case, when PFM sued her in Theranos, and the settlement was $43 million that PFM got back from their investment. Therefore, the $38 million is what they proceeded on at trial, right? They're saying it doesn't offset the loss, the amount of loss. Remember how I said it may offset the restitution, but as far as calculating the amount of loss, the government can argue, and also the probation looks like in their pre-sentence calculation, included the $96 million. So that's how we're starting to come up with the 550 million. And they're saying here, Mosley, the RDV, the DeVos family, PFM investments, if you add that up, it's $202 million loss. And then if you include the amount of that they took in, so the prosecution wants the judge to look at all the conduct, all of it, right? Even though she was acquitted on some of these patient counts, and even though the jury was undecided on some of these investor counts, the prosecution wants the judge to look at all of the conduct, and there's case law to support that. Whether or not they win on this argument, we'll see. But they're saying here between September of 2013 to 2015, Holmes raised $730 million. She raised that, including the amount which she was convicted of, with Mosley's count, those other counts. But they're saying all the money that she got from round Series C, C1 investors and C2 investors, you add all that up, including the 38 million from the PFM fund, the 99 million from the DeVos family, the 6 million from Mosley. If you add all that up, it's 730 million. But also, we want the court to also include the 30 million that Walgreens lost and the 30 million that Safeway lost and the 40 million that Walgreens lost. So you add all that up and it's approximately $803 million. But how do they get to in excess of so that's in excess of 550 million. So what the prosecution is arguing, that 803 million is way beyond the 550 million that's on the sentencing table. So Holmes exceeded even that. Okay? But they're not asking. Nobody's asking for that level 43 for life in prison for Elizabeth Holmes. They're asking the court to not apply, or I should say, vary. It's called a variance, or maybe it could be argued leniency from the sentencing guidelines. And the prosecution is saying all these people lost their money. They still lost their money. So here's what the defense argues. This is, I think, what they were getting to about the substantial value of Theranos. Somehow the loss should be offset by that. So here's what the prosecution says. So look at line 25. The actual loss must be reduced by some hypothetical fair market value of Theranos. Prosecution is saying that defies logic, and they're relying on this case, the Zolp case, which again is in the public company context, which I think the defense might argue doesn't apply. But let's just go with this. So what they're arguing here, the defense is arguing, okay, if these investors lost 803 million or 144 million, we still need to reduce that amount by the fair market value of Theranos at the time the fraud was discovered, because the patents had value, because there was underlying, value, substantial value according to the defense in Theranos. But what the prosecution is arguing is that defies logic, because once that Wall Street Journal article came out in 2015, there was no market value for any of the shares held by any of the investors. Therefore, it was a complete loss to the investors. The defense is saying, no. Theranos still had a substantial value. Therefore, the court should take that into account, and they should deduct it for the amount of loss that the government is claiming. Okay, so how do they come up with that? Now, again, there's significant portions of the defense's sentencing memo that are blacked out, redacted. So I don't know. So I'm just kind of speculating here. But because the government got an expert, and if you look at line 18, by the name of Carl Saba, and I hope I'm saying his name right, who's a certified valuation analyst. Basically, he values businesses. So the government asked him to give an opinion. What was Theranos worth? at the time that these frauds occurred, when these investors were investing in Theranos. So this expert gave a fair market value. What did they come up with? Look at line 4. They said that the estimated value, if you take the difference, the loss measured by the difference between the price paid by the investors, that 144 million, or if you want to go to the 803 million, but 803 million, and you deduct it between the estimated value of Theranos at the time of these crimes, this expert, the government's expert, the valuation expert, is saying it's between 237.2 million or 3 million to 273 million. So even if you do the calculation, it's still 237 million. And then the government says, okay, if you take that 803 million minus the 273 million, which is the valuation, the loss difference, that comes to an amount over 550 million. Therefore, the step increase, as cited in the calculation, is 30, a level 30 step increase, not 26 and not 24. So the prosecution also says here at line 9, in no event should the loss be less than 150 million. So if you add that 144 million, the estimated of the 3 convicted, plus the conspiracy, which could take into account all these other investor losses, they're saying at a minimum, Your Honor, it's 150 million, no less than 150 million, which would still leave her at, let's take a look here. Let me double check. I'm correct about this. I think level. So even if she's at 150, even if the loss is 150 million, it is no less than 150 million. It is adding level 24. So that's the level 31. So that puts her right at what probation is recommending, level 31, which is 9 years. So I think the government is kind of saying, well, if you're going to do that, then at a minimum 9 years, okay, plus the enhancements. So here's the other area in dispute. And again, these are areas ripe for appeal, right? So say if the judge wrongly calculates, and I don't think that's going to happen in this case, but if they wrongly calculate or there's a valid issue on appeal regarding how the sentence was calculated, it's called procedural error, and the case could be sent back for a resentencing of Elizabeth Holmes, like they did in the Scott Peterson case, right? Or it could even result, worst case scenario, of her convictions being tossed out. So here's the next thing they argue about. One was the calculation of loss. The next thing is the amount of victims. The defense is saying there wasn't more than 10 victims, therefore no step increase, no enhancement. So the government is saying, no, there were 7 investors who testified at trial, and there were 9 additional investors who had provided statements. So there's more than 10. So the enhancement applies. Then they argue that the risk of harm to Theranos patients by putting out a device that was unreliable, it's not accurate according to the prosecution. Government wants a 2-level enhancement because they're saying that Holmes, despite knowing the serious flaws, she continued to promote those tests and offered them to patients would put patients and the public at a significant risk of death. Therefore, she should be given an enhancement. And they're saying the government doesn't have to show any actual harm. And it also doesn't have to show that she subjectively knew that she was causing harm. It's an objective standard, not a subjective standard. And here's the part about Elizabeth Holmes actually saying, according to one of these statements, they don't put pretty people like me in jail. Did Elizabeth Holmes actually say that? They don't put pretty people like me in jail? Well, I guess we're going to find out on November 18th whether or not Holmes is going to jail. So the government argues here that she knew, she was conscious of the risks. She was actually warned by a consultant with Walgreens by the name of Kevin Hunter in a conference call that he had with Sunny Balwani and Elizabeth Holmes, where he said he admonished her that the company was going to offer lab tests that people would use to make medical decisions and warned her of the risk that she could be responsible for killing someone if the lab put out bad tests and that she might go to jail. She was warned, according to the prosecution, by this Walgreens consultant. And what did Elizabeth Holmes say, according to this Walgreens consultant? She said they don't put, I can't say this, they don't put pretty people like me in jail. Wow. Then they go on to say, well, there was an email with Christian Holmes where he said, what about having a candid conversation with Elizabeth? Because it's pretty obvious there are issues with accuracy. That's what the government is alleging. An email from her brother shows that she was put on notice. The text between Balwani and Holmes, and again, if you look at those breakup text messages, that video I did, or the revealing text video that I did, Balwani tells her the lab is a effing disaster zone. Was she on notice or not? According to the prosecution, she had ample notice, so therefore her sentence should be increased. Then the government argues that the patients, the treatment of the patients is relevant conduct too, because it could enhance her sentence. And even though it was impossible to know why the jury didn't convict Elizabeth Holmes, she was acquitted on these patients' counts. The judge could, by applying the preponderance, the lesser standard than the reasonable doubt standard, the judge could find that she is responsible for the conduct and for defrauding the patients. That's not going to be easy, not going to be an easy one. But they do argue that the judge could consider the same course or conduct, the investors and the patient. It was the same course of conduct, Your Honor. Therefore, she should be responsible for defrauding patients as well. All right, you can go ahead and read that. And here's the other argument the defense is saying. Her role in the offense. She's not a leader. She's not a manager. There's no extensive criminal activity here. Therefore, the government's not entitled to a 4-level increase. The government says, yes, she is. She made the decisions. She had a hands-on operator. She was a manager. She was a leader. And it was extensive. She had unsurpassed, look at line 28 here, unsurpassed level of authority. She wielded inside her company. She acknowledged, I think it was actually in the interview on the Today Show with Maria Shriver, that she acknowledged that all roads ultimately lead to her as the CEO. She was the largest shareholder in Theranos. She was the president of the board, and they're going to argue, the defense is going to argue, oh no, she wasn't a leader. That's going to be a tough one for the defense, I think. The government's also arguing she restricted the flow of information. In other words, she was intimately involved. She was hands-on. She was the leader of Theranos. That's what the government is alleging here. She understood that and this is interesting here, look at line 18. She understood that her status gave her the power to terminate anyone in the company, including Balwani, which I pointed out in prior videos. Maybe that's something that the prosecution is going to argue. If Elizabeth Holmes is going to say that she's a victim of domestic violence, and again, these are all allegations, that she is a victim of domestic violence by Balwani, and by the way, we don't know if there were confidential reports submitted to the judge in the pre-sentence report. Did she get letters? I don't know, because it didn't look like it when I reviewed the defense's memorandum, sentencing memorandum, but it doesn't mean that there weren't letters submitted by counselors or a domestic violence expert who gives an opinion to the judge and says, yes, Elizabeth Holmes is a rape victim, a domestic violence victim. Here are the reasons why. This is how it could have impacted her. So therefore, she wasn't really exercising control wasn't a leader. But keep in mind, they didn't put any of that testimony on in the trial. They didn't call a domestic violence expert. But I don't know. Those reports could be confidential, and maybe they were submitted for purposes of sentencing. But if she could fire Balwani, could the defense argue that is that it? If she's able to fire him, does that mean it's a valid that if he was controlling her and but she still fired him? Maybe that's not consistent. I don't know. So here's the other thing that government argues: the fraud was extensive. Therefore, she gets a 4-point enhancement because she used used participants unknowingly. These participants were unknowing participants to perpetrate the fraud. All the employees, the media, to help further the fraud, the demonstrations that were given to the investors, all these people that were involved unknowingly in this fraud, that she should be responsible for that, and her sentence should be enhanced because of that. Okay, you can go ahead and read through all this. And they talk about a call, when they would call in doctors or patients to Theranos, the call center right here. They were told when I talk to physicians or guests, I try to offer them different variables. Of course, none of them had to do with our testing methods. So who told the customer service people to say this? The use of other employees to appease doctors and patients troubled by dubious results was an important part of Holmes and Balwani's plan, that conspiracy to defraud patients and investors. Okay, there's a large number of investors. The state national borders were involved. Holmes organized and led criminal activity that was extensive. Therefore, she should get all those enhancements. You can go ahead and read this. And then let's see. Here's the part about the history and the characteristics of Holmes. This is where the judge has discretion, right, as to whether or not, there's nothing in the sentencing guidelines that say you can add or subtract. This is left to the judge here. So Holmes's histories and characteristics, the government argues, are aggravating factors, not mitigating. Aggravating because she has a strong family support. She was given many educational opportunities. She went to Stanford, right? She was also had significant support networks. And all of that, she still engaged in criminal activity, according to the prosecution and according to those convictions. And she had financial stability. And she chose to commit fraud anyway, and repeatedly. Those are aggravating factors according to the prosecution. And here's the deterrence part, or the policy part here, is the court should send a clear message to the community that white-collar crime is serious and deserving of significant punishment. Now, I'm sure the defense is going to be arguing, well, you don't need to make Elizabeth Holmes an example of that. Deterrence should be just applied to her. What will deter her? Back to that martyr for, what did they say, martyr for public passion? To send a message to the community? Well, again, that's up to the judge. But look at what the victim impact statements, we don't have them because they're not part, we don't have the pre-sentence report, which they would be a part of, but they're not part of these sentence memorandums. So Craig Hall, who's an investor, he said that the message should be sent clearly and unequivocally communicate that there is no justification or tolerance of fraud in the business world. Aiding entrepreneurial efforts of hardworking, honest Americans, bolstering the economy and fostering the American dream were impacted by what Elizabeth Holmes did. Brent Bingham, which was one of the patient counts, which was, I think, dismissed because of late discovery, he said, I feel sentencing should reflect a standard that medical-related technology shouldn't be beta tested on patients without consent Medical related technology should not be beta tested by patients without consent. Very interesting. Medical technology companies should receive a very clear message that placing finance and first to market considerations above engineering and science is not acceptable. Another victim impact statement. Elizabeth Douse said that penalties for white collar crimes seem too often to be a slap on the wrist. People and companies perpetrating financial fraud often get light, if any, sentences in a minimum security prison and keep most of the stolen money. So here, several victim impact statements are saying, Judge, send a clear message to the community. Okay, so here we get into deterrence. Again, prosecution is saying, general deterrence, Your Honor, send a clear message to would-be offenders that there's severe consequences if you engage in this conduct. Because economic and financial-based crimes are more rational, cool, and calculated than the sudden crimes of passion. These crimes, fraud crimes, white-collar crimes, are prime candidates for general deterrence. Yes, they are. But do they apply to Elizabeth Holmes, right? Is this a martyr for public passion by sending a clear message? I don't know. We'll see what the defense argues. And then they bring up the fact about companies rely upon state investments to fund ideas. Companies rely on investments. These investors to fund their dreams, their ideas, their companies. Investment relationships are built on trust. Unfortunately, Holmes' crimes damaged the trust and integrity that are necessary for this community to thrive. The prosecution is saying what Elizabeth Holmes did damaged the trust and integrity that's necessary for this community between entrepreneurs and investors to thrive. Well, maybe an argument can be made, where's the proof of that? I know it sounds like that's what happened, but where's the proof? Okay, just putting it out there. Again, my opinion, a significant custodial sentence will serve not only to deter future startup fraud schemes, but will also serve to rebuild the trust investors must have when they're funding innovators. Again, where's the proof of that? All right, there wasn't the evidence at trial, but it is in the victim impact statements, okay? So, the purpose to protect the public, that's another consideration the judge applies. And that relates to specific deterrence to Elizabeth. What would deter Elizabeth from doing this? And guess what? Look at line 23. Guess what Elizabeth Holmes is working on, according to the prosecution? She's working on new patents involving chemistry within the healthcare space. So the prosecution is saying she's still doing it. She's coming up with these patents in the healthcare space. So how is this a deterrence to her? We need to send a message to her of a sentence that deters her. And they also point out that the SEC in the settlement with the SEC, she's still allowed to be an officer and a director in the future. So how is that deterring her from doing the same thing again? I think is what the prosecution is arguing. And here's what came out in the trial testimony when she was asked, and holding a patent doesn't necessarily mean the invention works. She said yes. The prosecution said, for example, you don't have an indigestible pill that enables you to measure lipids in the blood, correct? She answered, not yet. Very interesting. And then they point out to the judge that Zone D, which is what the level 31 on with probation and prosecution is recommending, and I would also argue even the defense, because level C and D require custodial sentences. They're not home detention eligible. All right, so you can go ahead and read the rest of this. Oh, and here's the last part. I'll get to this quickly because this is probably getting quite long. You can read this. I want to get to we don't have the pre-sentence report, but if you look at line 16 here, it looks like that the probation was persuaded to vary the sentence from that level 43 down to a level 31, which is an 11-year variance because of her family and her social support, because of collateral punishments. That means all of what's been going on in the media, the focus, the media attention on this case, all the social media, all the vitriol, I imagine, all of that, the public shaming, if I can use that word, that's going on, which I'm sure the defense is arguing, and maybe that's what comprises the collateral support. Again, I don't know because there's redacted versions. There's a redacted portion in the defense's memo, and I don't have the pre-sentence report because that is confidential. So that is why the probation is varying the sentence 11 years less, 11 years from what's the level 43. Okay, so it's a variance of 11 years. With the prosecution says that's not justified, Your Honor. That's too significant of a variance. We want you to impose 15 years, not 9 years. And because it won't be enough of a deterrence, and it's not promoting respect for the law. So, Your Honor, apply the 15-year sentence, not the 9 years recommended by the probation. And they also say, as far as the collateral consequences regarding the significant media attention, well, Elizabeth Holmes sought out the media. She actually used the media, according to the prosecution, to put out all these false statements that appeared not only on our website, but also in the Fortune magazine article, the Wall Street Journal article, the interview with Jim Cramer on Mad Money, the interview on the Today Show, etc. Elizabeth Holmes used the media. Can she turn around and say, well, because of all this attention I'm getting, I should get a reduced sentence because of the collateral consequences? I don't know what's in that probation's reasoning for collateral consequences, but they also mention the trauma, her experience with trauma. Now, we don't know if the trauma is the rape in the alleged rape at college and the alleged domestic violence allegations. We don't know what trauma means, but the probation is using that for reason to recommend less. Recommend 9 years, not 15 years, and not 80 years for that matter. Okay, so you can go ahead and read this. Now let's look at, I thought was interesting, the last part of this. So stick with me here because this is interesting. The prosecution looked at what kind of sentences have been imposed for similar cases across the federal bench. So looking at fiscal year, so 2017 to 2021, there were 29 offenders who were at level 43, which is where the sentence calculation is for Elizabeth Holmes, so at the same level. And the average sentence of prison was 226 months. So what is that? I can't even do it. What is that? How many years is that? 20 years? Is that right? Let's see. Yeah, over 20 years. I think I did my math right. But the median length is 180 months. So doing a median calculation of the 29 offenders over the last 4 years, the median sentence is the exact sentence that the prosecution is asking. Very interesting. But let's look at, and the prosecution says that there's roughly 6 fraudsters per year at the top of the guidelines, the maximum guidelines, which is where the calculation is for Holmes. And they also say here, I thought it was interesting, line 16, while one may think this prosecution is unique, the data suggests otherwise. And they go on to show all these cases, and take a look. 8.6 billion defrauded. The sentence was 120 months. Well, the government's asking for 180 months and 550 million. That's interesting. More than 100 million. They got 204 months. Well, but the prosecution is asking for 180 months. Do you see the variation here? Again, more than 100 million got 144 months. More than $1 billion got 300 months. More than 400 million got 144 months. 31 million got 264 months. 31 million got 264. But scroll down here. See where it says EJD? That's this judge. These are his cases. There was a fraudster of 45 million. This judge imposed a sentence of 140 months, but it was with cooperation. Elizabeth Holmes did not cooperate. And the amount of loss, even if you add up those three investor counts as far, is 3 times 45 million. But that fraudster got 144 months, but cooperated. Here's another one where the judge sentenced another fraudster, 45 million loss. That fraudster got 130 months. Then there's another judge, same district, 47 million. That fraudster got 100 months. So that's looking like the probation department's recommendation of 108 months or 9 years is well within this range here. So very interesting. And again, they go on to restitution. The defense made a point, which I thought was quite interesting, about saying, basically, I'm going to paraphrase, if these investors were wealthy, we don't have to pay them back. Well, the prosecution is pointing out the victims are entitled to full amount of their losses without consideration of their economic circumstances of the defendant. So in other words, whether the defendant is rich or poor, they're entitled to be to get their full money back, to get their restitution. And they talk again about preponderance of evidence standard and whether or not it's 803 million restitution, which of course I'm sure the defense is going to say that doesn't apply because it's a higher standard, it's clear and convincing, and that a government hasn't shown that. So, and the government says here, if the judge is uncertain as to what the amount of loss is, make a final determination. Do it in 90 days. You don't need to make the decision here. Let's put it out in 90 days. Let's have a hearing and make a final determination. It's basically, let's just have a restitution hearing 90 days later and determine what the appropriate amount is. But go ahead and sentence her now anyway. All right? Then it was interesting. They pointed out that Holmes has modest assets, but she has a $450,000 loan to somebody for the amount that she gave in the SEC settlement. And they're also pointing out that her legal fees are in excess of $30 million, and it's unknown as to who's funding any of this, or if anybody's funding it, who knows. And that they asked the court to assure itself that the liabilities are current and genuine, and consider whether Holmes managed her affairs to reflect a general desire to make her investors whole. So I think what that's saying there, if I'm reading that right, is that maybe Holmes did some things to keep her assets separate so that her partner or anyone else wouldn't be implicated, or those assets wouldn't be forfeited or touched by this sentence. I don't know, because I don't know what the pre-sentence report says. Okay, so I think that is it. I think I covered everything. Yes, I did. So thank you for staying with me. And what do I think the likely outcome is going to be? I said initially, way back when in my very first video, that I think it's somewhere in the range of 8 years, and I'm sticking with that. I still think, I think maybe, 8 or maybe 9 years, what probation recommends. But the court could impose the sentence that the judge feels appropriate. The judge could give more than the 9 years. The judge could split the difference between the 9 years probation recommends and the 15 years that the prosecution recommends. Again, I don't think it's realistic that she's going to get home detention. But again, I don't know what's in that pre-sentence report. I don't know if there are counseling records. I don't know if there's, devastating impacts to Elizabeth Holmes that the judge is going to consider. I don't know about any of that. But just based on this probation sentence calculation that they did, it's level 43. So the sentence is at the discretion of the judge. So you tell me, what's your analysis? What do you think the sentence would be, possibly could be for Elizabeth Holmes that the judge will impose? So go ahead and vote on our poll. It's on the community page. What's your analysis? What do you think the possible sentence could be? Please do leave a comment or question. I'm curious to see what your analysis is. Hit that like button, hit the bell notification, share these videos, and if you want to contribute to me making these videos, I'll put a PayPal link in the description box below the video. Thank you so much for subscribing. I appreciate the continued support, and please do support my work by subscribing. Thanks for watching, and by the way, I'll do a separate video posting it next on answering the many questions I've got regarding Elizabeth Holmes' sentence. So thanks again for watching, and do subscribe.